Welcome to bongosikha, students. Today our discussion topic is the preamble. So what is preamble? Before knowing that, we have to, as a true citizen of India, it is our duty to know our constitution very well. So preamble is the philosophy of our constitution. So that is the basic thing which you have to remember. The preamble is the philosophy of the constitution. On January 1947, the drafting resolutions which has been drafted by Pandit Jawaharlal Nehru adopted the Constituent Assembly adopted the objective resolutions which has been prepared by Pandit Jawaharlal Nehru. So the preamble is the philosophy of the constitution, and preamble begins with the words. Always preamble starts with the words in the constitution that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice of social, economic, political, and to ensure to all its citizens equality of opportunity in the matter of the public appointment, to ensure dignity of the individual and the equality of status and opportunity, liberty of thought, expression, belief, faith, and worship, and to inculcate the values of the fraternity, that is the sense of the brotherhood among the all the individuals, and the integrity of the nation. So it promotes to secure to all its citizens justice, social, economic, political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them all, and fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So this is what the preamble starts, that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. So as preamble starts with the words that we, the people of India, so here the meaning sovereign republic comes. Because I am going to discuss that today's discussion, I have told the meaning of the preamble. That preamble is the philosophy of the constitution. Now I am going to discuss about the meanings of the sovereign, republic, democracy, liberty, equality, and fraternity. Next, socialism and secularism, which has been incorporated later in our constitution. Next, all the fundamental rights, and in brief, the writs. That there are the writs are there, 5 writs are there: the habeas corpus, writ of mandamus, the writ of prohibition, writ of certiorari, and writ of quo warranto. So these writs I will discuss one by one. So first I am going to discuss that is the sovereign republic, because preamble begins with the words that we, the people of India, which clearly indicating that on whose authority the constitution rests. That ultimately, that clearly indicating that the people of India, on whose authority the Constitution of India rests. Because the sovereignty means that the internal and external control over the whole territory of the India. So the Constitution of India derives its ultimate sovereignty from the people of India, on whose authority the Constitution rests. And what is important, that India is a republic, because India derives its power directly and indirectly from the people of India. So India is no longer a dominion, it is a republic, because always republic derives its power from directly and indirectly from the people, and is administered by a group of people or few persons with the during the pleasure, who will hold their office during the pleasure for a limited period or during their good behavior. So this is the basic connotations of the term sovereign republic. That republic derives its power directly and indirectly from the people, and is administered through a group of people who hold their offices for a specific period during their good behavior and during the pleasure of the limited period. So that is the main thing. Next, I am going to discuss about the democracy, the term democracy, because we all know that India is a democratic country, India is a democratic nation. The term democracy in all its form denotes the common participation of the people, that people will involve. It is neither authoritarian, it is nor any totalitarian state, no any military power dictates the terms, conditions of our country. The people itself engage themselves by casting their vote. One person, one vote. That is for the Indian democracy. That is called the universal adult franchise. By casting our vote, suffrage, the meaning of this word is vote. Suffrage কথাটার অর্থ মানে হচ্ছে ভোট দিচ্ছি। যখন আমরা আফটার অ্যাটেনিং দ্য এজ অফ দ্য 18 ইয়ার্স, আমাদের যখন 18 বছর বয়স হচ্ছে, তখন আমরা এই ভোটটা দিতে পারছি। So India, the term democracy in all its form denotes the common participation, সমস্ত মানুষের একটা কমন পার্টিসিপেশন, তারা পার্টিসিপেট করছে, তারা পার্ট নিচ্ছে ডেমোক্রেসিতে। সেটাই কিন্তু ডেমোক্রেসির সার্বিক মূল্যায়ন, সার্বিক তার অর্থ, সমস্ত দিকটা যেটা ডিকটেট করছে। অ্যান্ড ইন্ডিয়ান কনস্টিটিউশন মেক্স এনাফ প্রভিশন ফর দ্য ডাইরেক্ট ডেমোক্রেসি, বিকজ ইন্ডিয়া ইজ আ such type of, India is a country of almost 133 millions of people. So it is not possible for India to adopt direct democracy, because Parliament has made no provision for initiating direct democracies. There are several provisions in case of direct democracy, like referendum initiative. In case of India, there is no provision for the direct democracy, because it is not possible to engage all the people in the to come and take part in the political affairs of the country. That is why after every 5 years, or all on before that, if it is required in case of a hung parliament or coalition government, if the government fails, then we cast our votes so that our representatives will act, they will carry, they will forward our messages to the parliament. That is why that India, the democracy, Indian democracy or Indian constitution has adopted the indirect democratic system. So that is the meaning. So beyond political democracy, our constitution also envisages, that is the economic democracy and political democracy. And Dr. Ambedkar said or considered that social and the economic democracy is the real goals to be strived for. So it is very important that the economic and the political democracy, which are the real goals to strive for. Next, justice. The preamble speaks of the social justice, economic justice, and political justice. So social justice, what social justice implies, that there should not be any discriminations on the basis of a birth, caste, creed, race, sex, place of birth. To that end, all the citizens will enjoy equal opportunities in the matter of the public appointment. What I told earlier also, that all citizens will get the equal status, equal opportunity in the matter of the public employment. Next, economic justice. What economic justice? Economic justice always aims to bridge the gap between the haves and the have-nots. মানে যাদের আছে আর যাদের নেই, তাদের মধ্যে এই যে দূরত্বটা, তাদের মধ্যে যে একটা গ্যাপ, যে ধনী এবং দরিদ্রের, এই গ্যাপটাকে পূরণ করার জন্য কিন্তু ইকোনমিক জাস্টিস ইমপ্লাইজ that exploitation should cease. Exploitation should not be continued, and to that end, removal of poverty is to be achieved only by the equitable distribution of the natural resources among those who contribute to its creation. So this is all about economic justice. Next, I am going to discuss about the political justice. Just now I have discussed this political justice, that one person, one vote, that denotes the common participation of all the people in the political affairs of the country, to participate in the political system. Next, I am going to discuss about the liberty. Democracy, whenever we are talking about the democracy, the idea or the concept of democracy is closely connected with the concept of the liberty, because in order to live a free citizenship, that it is basic, or it is the fundamental to enjoy certain minimal rights by all the persons in a civilized society. It is the basic, it is the minimum criteria for all citizens, for every Indian citizen to live according to his own. So that is why there are the preamble also gives the freedom of thought, expression, belief, faith, and worship. That is why, as we told, that there is the liberty, that is the freedom of thought, expression, belief, faith, and worship. That is also entitled or enshrined in the preamble. Next, I am going to discuss about the equality. Right now, we have discussed that equal status, equality of opportunity. So, these rights will be meaningless if they cannot be enjoyed equally. If there is no equality, then what is the purpose of giving the rights? So, all the rights which has been guaranteed, so that can be enjoyed equally by all the members of the community. The fundamental rights enjoin the state not to discriminate between the citizen and the state simply, just now I have discussed that, simply on the basis of the race, caste, sex, place of birth, creed, so that exploitation should cease. The rule of law is to prevail. The rule of law, what is that? That all citizens are equal before the law and will enjoy the equal protection of the laws of the land. So this is very important, that rule of law, that equality before the law of the land, and all the citizens will enjoy the equal protection of the laws of the land. And fraternity. Next, I am going to discuss fraternity. That is the sense of the brotherhood. Our democratic system can function or would function in a healthy manner only if there is the sense of the brotherhood, there is the sense of the unique identity that I am Indian. Not that I am Hindu or I am Muslim or I am Jain or I am Sikh, but first that I am India. That sense of brotherhood, that spirit of brotherhood, of oneness among the people of the land is utmost important. So that is the fraternity. Next, that I am going to discuss about socialism and secularism. Originally, these two terms, socialism and secularism, were not incorporated or were not enshrined in the Constitution or in the preamble, and it was introduced in the preamble by the 42nd Amendment. So, what is the meaning of the socialism? Socialism always gives emphasis on the mixed economy. Exploitation ceases, and there should not be any vested interest, elimination of the inequality in every matters, in matters of public employment, in matters of education. There should not be any inequality. So elimination of inequality is utmost important. And the term secularism was included in the preamble in the 1976. What is the meaning of the secular? The secular is completely the word of the theocratic state. Theocratic state means what? The state who is having any official religion of its own. But secularism means that the state will not will not hold any particular religion of its own, and all the cultures, all the religions will have equality in matters of profess, practice, and propagate their own religion. So all will get religious freedom. That is the essence of the socialism. Next, I am going to discuss about the fundamental rights. The Indian Constitution incorporates a list of fundamental rights and guarantees their inviolability by the executive organs and the legislative authorities. Part 3, Articles 12 to 35. They deals with the fundamental rights guaranteed to the individuals. But originally there were 7 fundamental rights. With the deletion of the right to property, now there are 6 fundamental rights. So the fundamental rights, now I am going to discuss that fundamental rights are very important for the development of the human personality, promoting individuals' dignity and welfare. Without fundamental rights, it is not possible to think of a healthy environment, healthy state, or smooth functioning of the democratic system. So fundamental rights are integral part of the democratic system. So now I am going to discuss the fundamental rights. I am starting with the fundamental rights, that is the right to equality. So Article 14 provides the state shall not deny any person equality before the law or the equal protection of law within the territory of India. সো ইন্ডিয়ার মধ্যে কখনোই আর্টিকেল 14 যেটা বলে দিচ্ছে যে স্টেট কোনো মানুষকেই ডিনাই করতে পারে না ইকুয়ালিটি বিফোর দ্য ল। হাউএভার exceptions are there to the governor and the president of India, and the equal protection of the law means the right to get the equal treatment in the similar circumstances. That is the meaning of the line of this above quotation, that the equal protection of the law. So that is the essence of the Article 14, that rights to equality. Next I am going to discuss about Article 15. Article 15 available only to the citizens, that there should not be any prohibition, any restrictions regarding the use of any public toilet, any public wells, any parks, children's park, any museum, any libraries, any hotels, restaurants, simply on the basis of the caste, race, sex, place of birth, creed. So there should not be any such discrimination. That is the main motto of the Article 15. Next, Article 16 assures every citizen of India the equality of opportunity in matters to the employment. So this is the essence of the Article 16, that there should be always equality of status in matters of the employment. Article 17 abolishes the practice of the untouchability. Earlier, that Harijan, Dalits, those who are the lower caste, that was they were considered untouchables, যে তাদের হাতের কিছু নেওয়া হতো না, তাদেরকে পাবলিক টয়লেট ইউজ করতে দেওয়া হতো না, কোনো জায়গায় কোনো কুয়ো থাকলে সেখানকার জল তারা খেতে পারবে না, কারণ তাদেরকে কনসিডার করা হতো, যেটা মহাত্মা গান্ধীজি তাদেরকে যার জন্য বলেছে হরিজন। কেন হরিজন বলেছে? কারণ তারা হরির জন, মানে হরি আমাদের যে কৃষ্ণ, আমাদের যে ভগবান, সেখানে তারা তার প্রিয় যারা, তাদেরকে মহাত্মা গান্ধীজি কিন্তু হরিজন বলে কিন্তু তাদেরকে অ্যাড্রেস করেছে। সো এখানে আমরা দেখতে পাই যে আর্টিকেল 17 এই যে জিনিসটা আনটাচেবিলিটি, এটাকে কমপ্লিটলি ব্যান করে দিয়েছে। Next, Article 18 কি করছে? Article 18 prohibits the state from conferring any title. Article 18 totally prohibits conferring any title. However, military and academic distinctions do not come under this ban, but no Indian citizen is entitled to, or can accept a title from a foreign state. মানে একই সঙ্গে তুমি ইন্ডিয়ার সিটিজেন হয়ে তুমি বিদেশ থেকেও আরেকটা তুমি পদ্মশ্রীও পেলে, আবার বিদেশ থেকেও তুমি একটা অ্যাওয়ার্ড পেলে, এরকমভাবে কিছু হতে পারে না। সো নো ইন্ডিয়ান সিটিজেন ক্যান অ্যাকসেপ্ট আ টাইটেল ফ্রম আ ফরেন স্টেট। কেউ ভারতরত্ন হয়ে আবার অন্য দেশেরও কিছু সে টাইটেল কিন্তু রিসিভ করতে পারে না। দ্য রাইট অফ ফ্রিডম শুরু হচ্ছে আর্টিকেল 19 থেকে। রাইট অফ ফ্রিডম আর্টিকেল 19 enumerates certain positive rights conferred to ensure the rights that promote the ideal of the liberty, that which we have told in the earlier, that the concept of the liberty, that rights are meaningless if there is no liberty, if there is no equality. So in order to promise or to promote the ideal of the liberty which is promised in the preamble, 6 fundamental rights are there in the nature of the right of freedom. So first is what? Freedom of speech, expression, everything subject to reasonable restrictions, only with interest to the public security and safeguard of the states, safeguard of our country. Freedom of the assembly. So you can assemble peacefully without any arms and ammunition, but it is subject to restrictions if it is related with the interest of the public order, sovereignty and integrity of the India. Next, freedom to form associations or unions. You can form associations or unions also, subject to reasonable restrictions, only on the grounds of the security and the integrity of the India, to safeguard our country. Freedom to move freely and settle throughout the territory of India. So anyone can reside and settle in any part of the territory of the India. That freedom is there, but here also the reasonable restrictions are there with regard to the sovereignty of the India, with regard to the safety of the India, with regard to the interest of the general public. So freedom to move freely. So what I told that next, that freedom to reside or settle in any part of the territory of India. Next, freedom to practice and propagate any profession, occupation, business, any throughout the territory of India. You can practice, propagate any occupation, any trade, any business. But that is also under the reasonable restrictions if it is with the interest of the public interest, if it is with the security of the country. So these are the six fundamental freedoms under Article 19. Next, I am going to tell Article 20, which accords protection to all citizens against conviction for the offences, that prohibiting by prohibiting retrospective criminal offence legislation or ex post facto legislation, punishment for the same offence more than once, and the compulsion to give self-incriminating evidence. Article 29 provides every Indian citizen the right to life and liberty by stating that in case of any violation of his life, in case of any violation of his personal freedom, he can move to the High Court and he can move to the Supreme Court also, which is guaranteed in the constitutional remedies under Article Judicial Writ of Habeas Corpus, that by Article 32 he can move to the Supreme Court, and under Article 226 he can move to the High Court. So that is the Article 21 provides protection to life and liberty to all persons. Next, Article 22 affords protection against arbitrary arrest and detention. So there are some safeguards are there, that the person who is arrested cannot be arrested without giving proper reason. So if there is no proper reason, he cannot be arrested. And the person who is arrested shall be produced before the nearest magistrate within 24 hours. So that is another safeguard. But these safeguards, however, the very important, that the right to be defended by a legal practitioner of his own choice. So that is the safeguards which are giving that protection against arbitrary arrest and detention. However, these safeguards are not available to an alien, মানে যে ভারতীয় নয়, এবং a person who is detained under the Preventive Detention Act. Preventive Detention Act মানে কি? Preventive Detention Act হচ্ছে which is related with the security of the nation. সো আমাদের ইন্ডিয়ার সিকিউরিটির স্বার্থে যেরকম কিছু কিছু অ্যাক্ট আছে, কফি পোসা, মিসা, মেনটেন্যান্স অফ দ্য ইন্টারনাল সিকিউরিটি অ্যাক্ট, কনজারভেশন অফ ফরেন এক্সচেঞ্জ অ্যান্ড প্রিজারভেশন অফ স্মাগলিং অ্যাক্টিভিটিস অ্যাক্ট, কফি পোসা, ন্যাশনাল সিকিউরিটি অ্যাক্ট, এইসব অ্যাক্টে যদি কাউকে ধরা হয় সেখানে কিন্তু এই ধরনের সেফগার্ডসগুলো আর অ্যাভেলেবেল নয়। এটা কিন্তু মনে রাখতে হবে যে ইস্যু অফ প্রিভেন্টিভ ডিটেনশনের ক্ষেত্রে কিন্তু এই মানে এইগুলো আর তখন সেখানে চলে না। Next, I am going to discuss about Article 24. Article 24 gives emphasis on the employment, that there should not be any child labor. So employment of the child in case of any hazardous jobs, mines, coal mines, below the age of the 14 years in factories is strictly prohibited, and there is no exception. The prohibition is absolute. That is, you have to remember, always you have to remember. So that is about Article 24. Now I am going to discuss the freedom of religion. As I told in the beginning that India is a secular state. India is having no official religion of its own. So every religious community is having its freedom to practice, profess and propagate any religion of its own. So there is no restrictions regarding this, that Article 25. Article 26 gives the right to every religious groups and the denomination the right to establish and maintain its own religious institutions and charitable purposes. Article 27 affords that no citizen will be compelled by the state, that there should not be any citizen who is compelled by the state to to pay any tax for the promotion or for the maintenance of its own religious belief. That is guaranteed by Article 27. Next, Article 28 stipulates that no religious instruction shall be imparted or shall be given. মানে কোনো ধরনের ধর্মীয় কিছু instruction you cannot give to any state funded school. So that is মানে it's strictly stipulated in Article 28. Next, that cultural and educational rights, that is that number 5 fundamental rights that cultural and educational rights. Article 29 stipulates that the state shall not impose any culture other than the community's own culture. Every religious minority, every minority community has the right to practice its own educational institution, has the right to practice its own religious institution. So you cannot impose anything that other than the community's own culture. And Article 30 confers upon the minority community the right to establish and administer their educational institutions of its own choice. Every educational institutions can establish its own choice, can administer its own the right to establish and administer educational institutions. The state is not to discriminate in granting such institutions in any aid. The state cannot make any distinctions. Whenever the state is granting any aid to that particular institution, the state cannot make any discrimination based on that. So that is guaranteed by Article 30. Next is the very important, that is the entire edifice of the Constitution, that is the right to constitutional remedies. That realizing the futility of granting that fundamental rights, that our Constitution makers realize that if there is no provision for realizing the futility of the fundamental rights, that if the entire process will be totally failure. So that is why they have given the High Courts and the Supreme Courts to issue writ against that following cases, that any person can move either to the High Court or to the Supreme Court in violation of his personal freedom, in violation of his life and liberty. So he can move any petition either to the High Court or to the Supreme Court. Dr. B.R. Ambedkar called it the entire edifice of the Constitution, the very heart of it, the very soul of it, the right to constitutional remedies. And under Article Constitutional Remedies, Article 32, there are several writs. That writs of habeas corpus. The writs of habeas corpus means to have the person in body. If in any case that if a person is missing for many days, for a long period, then the relatives or his family can report to the local government or to the High Courts and can move to the Supreme Court also, that to have the person in body, means either alive or dead, but you have to produce the body. So that type of writ can be issued by the Supreme Court or by the High Court. Next, the writ of mandamus. The writ of mandamus commands the person to whom it is addressed to perform that public duties, that is the writ and the performance of which cannot be enforced by any other legal remedy. So that is the writ of mandamus, that which commands the person to whom it is addressed to perform some public or quasi-public, means semi-public duty. Next, the writ of prohibition is issued by any superior court, by the Supreme Court to the High Courts or by the High Court to the distinct courts, to forbid the latter, means the lower court, to continue proceedings in a case in excess of its jurisdiction. If any court in excess of its jurisdiction uses its power and authority, so that type of injunction can be issued by the superior courts to the lower courts. The writ of certiorari is issued to a lower court after a case has been decided by it. So that is, in case of that, the writ of certiorari can be can be issued by the higher courts to the, if already a case has already been decided. And the writ of quo warranto is the proceeding by which the court inquires into the legality of the claim. So by the writ of quo warranto, by issuing that type of writ, that writ of quo warranto, any high court or any Supreme Court can claim the legality of that particular judgment. So this is very important. So these are all about the writs. 5 types of writs are there: habeas corpus, writ of mandamus, writ of prohibition, writ of certiorari, and writ of quo warranto. So this is all about preamble, fundamental rights, and the related writs along associated with this chapter. Thank you.